Okay, let's unpack this. Have you ever wondered about the intricate machinery that keeps a vast country like India running, or how constitutional powers are balanced?
It's a fascinating puzzle, isn't it?
Absolutely. Today, we're taking a deep dive into the world of India's governance. We'll explore how money is shared with states, the profound impact of emergency powers, and the ongoing evolution of its judicial system.
Right. Our mission here is really to distill the key insights, the surprising facts from, well, a lot of information. We want to give you a shortcut to being truly well-informed.
So we'll cover the critical work of the Indian Finance Commission.
Exactly. And the far-reaching implications of emergency provisions. Plus, the really complex journey of judicial appointments, right down to that persistent challenge of pendency in the courts.
Get ready then to discover the subtle shifts, sometimes dramatic moments that define how India governs itself and what it all means for you, the citizen.
Let's jump in.
Let's begin with the Indian Finance Commission. It plays such a pivotal role, deciding how funds flow from the union, the central government, to the states. Now, the 15th Finance Commission, they faced some genuinely controversial issues,
They really did.
especially around sensitive topics like population control. How did they manage that tightrope? How did they avoid, penalizing states that had actually done a good job managing population growth?
Well, that's where their approach got quite insightful, I think. A major sticking point was using the 2011 census data for devolution.
Right, the southern states were worried.
Precisely. They feared it would punish them for, well, effectively controlling their population. But the 15th FC, they didn't just use a rigid formula.
They innovated.
Yes, they gave 15% weightage to the 2011 data, sure, but, and this is crucial, they also gave a significant 12.5% weightage to the state's demographic performance.
Ah, so rewarding good performance.
Exactly. It was a new vital criterion. It effectively rewarded states managing their total fertility rate well, turned a potential penalty into, well, an incentive.
That's a really clever balancing act.
Yeah,
It sounds
yeah.
like they were thinking innovatively beyond just that core fund distribution, too. What else did they introduce? Things focused on strengthening states in other ways.
Well, another tricky one was the income distance criteria. Richer states like Karnataka felt their fiscal efforts were being punished.
So how did they tackle that?
The 15th FC brought in a 2.5% weightage for tax and fiscal efforts, basically acknowledging states working hard to raise their own revenues.
Okay, so rewarding effort there, too.
Right. And beyond these balancing acts, they recommended a huge sum, 1.6 lakh crore rupees, for state disaster management funds.
Wow, that's substantial.
It is designed to empower states for, localized financial preparedness. They also allowed states extra borrowing, about 0.5% of their GSDP, for power sector reforms.
And property tax, I heard that mentioned.
Yes, even made recommendations to improve property tax collection, often an untapped area for revenue.
So the 15th FC wasn't just looking at the big state finance picture, but also drilling down into local governance and the unique challenges there.
Absolutely. They clearly recognized that national strength starts locally. They provided special grants for improving panchayats and municipalities.
Local councils, basically.
Right. And introduced performance-linked incentives for good governance, think solid waste management, health reforms. They even recommended a non-lapsable defense modernization fund.
And sector-specific stuff.
Yes, proposed sector-specific grants, around 1.3 lakh crore rupees total, for areas like health, education, the judiciary. It was quite a comprehensive approach trying to empower governance from the ground up.
Okay, so considering all those balancing acts and challenges from the 15th, what major hurdles are now facing the upcoming 16th Finance Commission?
Well, a key challenge, and it's a perennial one really, is how to meet growing demands with finite resources.
Always the problem.
Indeed. Several states, Bihar for example, are pushing hard for a bigger slice of the pie in vertical devolution.
That's the share of central taxes sent to states.
Exactly. They're asking for up to 50%, up from the current 41%. And this demand gets louder because of the big increase in cesses and surcharges the union collects.
The specific levies that aren't shared.
Precisely. They're not part of the divisible pool, so it effectively shrinks the pot available for general sharing with states.
So these underlying tensions, like the income distance thing between richer and poorer states, they're still very much alive then. How does that shape the new commission's job?
Oh, definitely. It remains a persistent challenge. Plus, the union government itself is facing, shrinking fiscal space.
Making it harder to give more.
Makes it harder to accommodate increased state demands without cutting its own priorities. And then you have states with unique issues.
Like geographic or security challenges.
Right. Border states like Punjab, flood-prone regions like Assam, states dealing with insurgency like Meghalaya, Mizoram, Tripura. They're all asking for more compensation for their specific problems. So balancing these very specific needs, while also considering that north-south divide, states with growing versus stagnant populations, it's going to be a critical and very complex task for the 16th FC.
Let's pivot now to a really powerful, sometimes controversial part of India's constitution. Emergency provisions, specifically Article 352, national emergency. How does this dramatically reshape that power balance between the union and the states? It basically turns the federal system on its head, right?
That's a good way to put it. When a national emergency under Article 352 is declared, the federal structure can effectively become unitary.
So central government takes over.
Pretty much.
Oh.
Legislatively, Parliament gets the power to make laws on the stateless topics, usually reserved just for states. Executive powers centralized too.
Meaning?
The union can issue directions to states, even take over their functions directly. And financially, the union can suspend or change how revenues are distributed between itself and the states.
For how long?
For the duration of the emergency and the financial year it ends in. It's a complete centralization of power, designed, for exceptional circumstances.
Now, when an emergency hits, what happens to your fundamental freedoms? What's the impact on, well, your basic rights?
Right. A critical piece here is Article 358. It says Article 19, that's freedoms like speech, assembly, movement, is automatically suspended.
Automatically? Wow.
Yes, but only if the emergency is declared because of war or external aggression, not for armed rebellion. That's a key distinction added later.
Okay, so if it's suspended for war,
then the state has, virtually unlimited power to restrict those Article 19 freedoms, even unreasonably. As long as the law doing the restricting explicitly says it relates to the emergency, it's a vast power.
that's a huge shift. How does Article 359 then fit in? Does it offer any other protection or maybe a different kind of restriction?
Yes, it's a vital distinction. Article 359 allows the president, through an order, to suspend the enforcement of specified fundamental rights.
The enforcement, not the right itself.
Exactly. The rights still exist on paper, but you can't go to the Supreme Court or high courts to complain if they're violated while the president's order is active for that right.
But there's a major exception now, isn't there?
Yes, and it's crucial. The 44th Constitutional Amendment brought in a critical safeguard. The enforcement of Article 20, protection against unfair conviction, and Article 21, the right to life and personal liberty, cannot be suspended.
Regardless of the reason for the emergency.
Regardless, war, armed rebellion, doesn't matter. Articles 20 and 21 enforcement stays. That was a huge lesson learned from the past.
Speaking of the past and fundamental rights during emergencies, there was that truly pivotal and frankly quite dark moment in Indian legal history, wasn't there? Can you walk us through the ADM Jabalpur versus Shivkant Shukla case, 1976, the habeas corpus case? Why is it seen as such a low point?
It really was a critical and deeply troubling juncture. During the 1975 emergency, many citizens were illegally detained.
Just locked up without proper cause.
Yes. And high courts across India started accepting habeas corpus petitions. That's the legal writ, demanding the state justify someone's detention.
So people were challenging their detention.
Right. But the government took it to the Supreme Court. They argued that if the enforcement of Article 21, the right to life and liberty, was suspended by the president's order under Article 359. Then, the government argued, no one could seek any legal remedy at all for illegal detention, even if their life or liberty was being taken away completely unlawfully.
That sounds extreme. What did the Supreme Court decide?
In a, truly shocking 4-1 majority decision, the Supreme Court agreed with the government.
Agreed.
Yes. They ruled that if Article 21's enforcement was suspended, citizens had absolutely no right to approach the courts, even if their life or liberty was illegally taken. The majority essentially said Article 21 was the sole source of their right to life.
That's chilling. It puts liberty completely at the mercy of the executive during an emergency. It really makes you question the foundation of the rule of law in such times.
It does. A very bleak verdict for civil liberties.
But there was one powerful prophetic dissent in that 4.1 judgment, wasn't there?
Indeed. Justice H.R. Khanna, he famously dissented. He argued passionately that the right to life isn't just granted by Article 21, it's a natural right.
Something inherent.
Exactly. Flowing from the basic concept of the rule of law itself, not just the Constitution, he asserted that constitutional courts like the Supreme Court and high courts have a fundamental duty to protect these rights regardless of any emergency proclamation.
A brave stance. It cost him, didn't it?
It did. It famously cost him the position of Chief Justice of India, but his dissent was eventually and powerfully vindicated.
How was Justice Khanna's view finally vindicated? What changed the understanding of rights in India?
It took decades, quite remarkably. But in 2017, in the Puttaswamy case, the Aadhaar privacy case, the Supreme Court explicitly looked back at ADM Jabalpur and declared that judgment wrong. They fully affirmed Justice Khanna's view. They stated that the right to life and personal liberty are inherent natural rights. They exist independently of Article 21, and they cannot be taken away, even during an emergency.
A monumental correction.
Absolutely. A testament to the enduring power of that principled dissent.
So, the lessons learned the hard way from the 1975 emergency clearly led to those significant safeguards in the 44th Constitutional Amendment Act. What were the crucial changes designed to stop future misuse of these emergency powers.
Right. The 44th Amendment brought in several vital protections. First, an emergency can now only be proclaimed on the written advice of the entire Union cabinet.
Not just the Prime Minister deciding alone.
Correct. That vague old term, internal disturbance, was replaced with the much more specific armed rebellion.
Harder to misuse that phrase.
Hopefully. Parliamentary approval now needs a special majority, not just a simple one. And it has to happen within 1 month, down from 2.
Tighter timelines, higher bar for approval.
Exactly. And the proclamation itself only lasts for 6 months at a time. It needs fresh approval every 6 months to continue.
And what about the crucial impact on fundamental rights under these new safeguards?
Critically, as we touched on, Article 19 is not suspended if the emergency is based on armed rebellion.
Only for war or external aggression.
Right. And most importantly, the enforcement of Article 20 and Article 21 can never be suspended, no matter the grounds for the emergency.
That's the big one learned from ADM Jabalpur.
Absolutely. Plus, there's a mechanism for the Lok Sabha, the lower house of parliament, to force a vote on revoking the emergency. Just 110th of its members can call for a special sitting, and a simple majority vote can disapprove and end the emergency.
So much more parliamentary oversight and protection for core rights.
Yes, this whole set of reforms significantly limits potential executive overreach and protects citizens' fundamental rights far more robustly than before.
Okay, let's shift gears now and turn our attention to the judiciary itself. Specifically, the fascinating and often contentious process of appointing judges in India. Let's start right at the top. The Chief Justice of India, the CJI. The convention is to appoint the senior-most judge. How did that practice actually start?
It's interesting because the Constitution itself is actually silent on the criteria for appointing the CJI.
Really? No mention of seniority?
Nope. Historically, back in the early days of the Republic, there was actually an attempt to appoint a High Court Chief Justice directly to the CJI role.
Skipping over sitting Supreme Court judges?
Yes. But the sitting Supreme Court judges apparently threatened mass resignation back in the 1950s.
Wow.
And that pressure successfully established the convention of appointing the senior-most Supreme Court judge as CJI. It was seen as an assertion of judicial independence back then.
But this convention, born from such drama, it was notably broken twice, wasn't it? During a particularly sensitive period.
Yes, it was. Very controversially. First, in 1973, with Justice A.N. Ray, he superseded 3 judges senior to him. This happened right after the landmark Kesavananda Farati case.
The case establishing the basic structure doctrine.
Precisely. A judgment that limited Parliament's power to amend the Constitution. So appointing Ray was seen by many as the executive retaliating or trying to ensure a more compliant judiciary.
And the second time.
That was in 1976 during the emergency. Justice M.H. Beg was appointed, superseding Justice H.R. Khanna.
The very judge who wrote that powerful dissent in the ADM Jabalpur case we just discussed.
The same one. Again, widely seen as executive interference, punishing dissent and rewarding perceived loyalty.
So while seniority sounds simple, maybe even fair, what are some of the inherent problems that have cropped up with this seniority-based approach for the CJI?
Well, one significant issue is often called the rotating door syndrome. Strict seniority often leads to very short tenures for chief justices, sometimes just a few months. Justice UU Lalit, for example, had just a 3-month term.
That's not much time to make an impact.
Exactly. It significantly impacts their ability to initiate and see through any long-term institutional reforms for the judiciary. It also prioritizes just, time served over potentially crucial merit or leadership qualities needed for that top job.
And is it really immune from manipulation? Even if it's based on seniority, can politics still play a role?
Not entirely, no. The process isn't foolproof. For instance, appointments to the Supreme Court could theoretically be delayed or timed strategically, which then affects who eventually becomes senior enough for the CJI position down the line.
Influencing the pipeline.
Potentially.
Yeah.
And because it's still just a convention not formally written into law, history shows us, like in the 70s, that it can be overlooked or overridden by the executive if they choose to.
So what kinds of reforms are being suggested to tackle these shortcomings, to try and ensure both independence and effective leadership for the CJI?
Well, various proposals are floated, moving towards a mix perhaps of seniority and merit, making the whole process more transparent, maybe with publicly stated criteria.
And the short tenure issue.
Trying to ensure a minimum tenure, say 2 or 3 years, for the CJI. That might mean adjusting the retirement age or maybe only appointing judges who have enough service left to meet that minimum term.
What about making the convention law?
That's another suggestion, formally codifying the seniority convention to give it legal teeth and protect it better against arbitrary executive actions.
Okay, let's broaden out now to the appointment of other judges in the higher judiciary, the high courts, and the rest of the Supreme Court. This is governed by the Collegium system. It's quite unique, isn't it?
Mhm.
How did the system evolve? It sounds like it has a contentious past, too.
It certainly does. Originally, the Constitution just said the president should consult with the CJI and other relevant judges.
Consultation. Sounds reasonable.
And it worked reasonably well for a while, often based on consensus. But then came the period during and right after the 1975 emergency.
More executive interference.
Massive executive interference. There were over 200 high court judge transfers between 1975 and 1980, often seen as punitive. There was even a notorious circular from the Union Law Minister in 1980.
What did it do?
It basically asked potential high court judge appointees to sign declarations saying they'd accept temporary appointments or transfers anywhere. It was seen as undermining judicial independence. This whole context of executive overreach really set the stage for the courts to step in.
So this context and the judiciary wanting to push back and reassert its independence, that led to the first judge's case.
Indeed. In SP Gupta versus Union of India in 1981, the Supreme Court actually ruled that consultation in the Constitution meant just that mere consultation.
So the CGI's view wasn't binding.
Correct. This ruling effectively gave the executive the final, say, primacy in judicial appointments. It was seen as a major setback for judicial independence at the time.
So when did the pendulum swing dramatically back? When did the collegium system, as we basically know it now, actually come into being?
That happened with the second judge's case in 1993. Supreme Court advocates on record versus Union of India, this judgment completely reversed the first judge's case.
So?
It reinterpreted consultation to mean concurrence, meaning the CJI's views, developed collectively, were binding on the executive. This established what's called judicial primacy in appointments.
And it defined the first collegium.
Yes. For Supreme Court appointments, it was the CJI plus the two senior-most Supreme Court judges. For High Court transfers, it was a larger group, CJI, 4 senior-most SC judges, and the Chief Justices of the 2 High Courts involved. For High Court appointments, CJI, 2 senior-most SC judges, and the relevant High Court Chief Justice. And it also reaffirmed the seniority principle for the CJI appointment itself.
And then the third judge's case refined this further, made it more institutional.
Exactly. In 1998, there was a presidential reference seeking clarification, which led to the third judge's case. It stressed that the CJI's opinion must be an institutional one, reflecting a consensus, not just a personal view.
How did it change the structure?
It expanded the Supreme Court Collegium to the CJI plus the 4 senior-most judges. For High Court appointments, it said the Collegium must consult Supreme Court judges familiar with that specific High Court.
And record-keeping.
Crucially, yes. All recommendations and any objections must be recorded in writing. And if 2 or more Collegium members dissent on a name, the proposal has to be dropped. It was an attempt to build in some internal checks and transparency.
Okay, so despite these refinements and its evolution rooted in protecting judicial independence, the collegium system faces a lot of criticism today. What are the main complaints?
Well, the loudest criticisms are usually about its lack of transparency. It's often described as opaque, operating behind closed doors.
Leading to accusations of
Favoritism, nepotism, sometimes called an old boys network. Critics also argue it marginalizes the executor's role too much, potentially violating the constitutional principle of separation of powers.
and representation issues.
Yes, there's noted underrepresentation of women, minorities, and judges from certain regions within the higher judiciary, which some blame on the closed nature of the collegium process.
And what about the practical impact? How well does it actually function in, say, filling vacancies?
That's a huge practical problem. This raises a serious question about its sufficiency. The collegium system is frequently blamed for excessive delays and huge numbers of vacancies in the high courts especially.
Why the delays?
Partly, it's attributed to the lack of a permanent, dedicated secretariat to manage the complex process of vetting and recommending names. The administrative burden falls heavily on the judges themselves.
The vacancy numbers are bad.
They're stark. Out of around, I think, 1,100 sanctioned high court judge positions, often hundreds are vacant at any given time, sometimes close to 40% across the country. That's a massive operational gap.
Does it affect quality too?
That's also debated. Interestingly, even Justice J.S. Verma, who actually wrote the second judge's case judgment establishing the collegium, later expressed concerns about the quality of some appointments made under the system compared to earlier times.
So given all these issues, transparency, efficiency, representation, vacancies, what reforms are being suggested for the collegium system, how can it be improved?
Well, one major idea that keeps coming up is trying again with a National Judicial Appointments Commission, an NJAC.
Didn't the Supreme Court strike down the last attempt?
It did. The argument was that it gave the executive too much say and violated judicial independence. So any new proposal would likely need to ensure judicial primacy is maintained, perhaps with a different composition, maybe more judges, fewer executive members, but still bringing in some outside perspective.
What about making the current system work better?
Absolutely. Establishing an independent permanent secretariat for the collegium is seen as vital. just to handle the administrative load, streamline vetting, track vacancies, and reduce delays.
Learning from elsewhere.
Possibly. Some suggest looking at the UK practice, for instance, where candidates can actually apply for judicial positions and have to disclose potential conflicts like relationships with sitting judges. That could enhance transparency.
And balancing the executive's role without going back to the pre-collegium interference.
There's the Memorandum of Procedure, the MOP. It was developed around 2014 to sort of formalize the interaction between the Collegium and the government on appointments and transfers. The argument is that this MOP needs to be followed strictly by both sides in letter and spirit.
And intelligence reports on candidates.
That's a tricky area. The suggestion is that any adverse reports from agencies like the Intelligence Bureau regarding a judge's conduct need careful handling. Perhaps a proper inquiry should be held before a recommendation is dropped based solely on such a report, ensuring fairness.
Okay, this leads us right into another massive pressing issue for the Indian judicial system, one that affects every single citizen trying to access justice. Judicial pendency. The sheer backlog of cases. How bad is it?
It's truly staggering. The official National Judicial Data Grid shows over 5 crore cases currently pending across all levels of courts in India.
5 crore. That's over 50 million cases.
Yes, and to give that context, estimates suggest it takes, on average, something like 14 years for a case to potentially travel from a lower court all the way up to the Supreme Court.
14 years!
And over 15% of all these pending cases are more than a decade old already. While the bulk is in the lower courts, the high courts have over 5 million pending cases, and even the Supreme Court has tens of thousands. It's an enormous backlog.
That's an unbelievable amount of waiting. But just filling judge vacancies, while important, probably isn't the whole story, right? Pendency seems like a beast with many heads. What are some of the other systemic factors feeding this massive backlog? We're talking outdated procedures, lack of tech, or maybe not enough alternatives to court.
You've hit on absolutely key points. Vacancies are a huge factor, no doubt, but the problem is definitely multifaceted. Outdated court procedures are a big one. Many courts still rely heavily on manual processes, cumbersome paperwork, rules that haven't kept pace.
Slows everything down.
Immensely. Then there's insufficient digital infrastructure. While progress has been made, e-filing, virtual hearings, digital case management, they aren't universally or efficiently implemented everywhere. The sheer volume of litigation itself is another factor.
Too many cases being filed.
Perhaps too many trivial cases or cases involving multiple, sometimes unnecessary appeals, clogging the system. And crucially, as you mentioned, the lack of robust, easily accessible alternative dispute resolution or ADR mechanisms.
Like mediation or arbitration.
Exactly. If more disputes could be settled effectively outside the formal court system, it would significantly reduce the burden. Right now, it often feels like court is the only option, which swamps the system. So yes, it's not just about judge numbers, it's about modernizing the entire judicial ecosystem.
And beyond the direct denial of justice for the people stuck waiting years, this huge backlog must seriously erode public trust in the whole legal system, right? Is that something we see?
Without a doubt. It leads to a profound denial of justice, especially, as you'd expect, for the poorest and weakest sections of society. They simply can't afford these prolonged legal battles.
So justice delayed is truly justice denied.
It absolutely is in this context. It also weakens the deterrent effect of the law. If people think they can just drag out a case for years and years, where's the disincentive for wrongdoing?
Good point.
Ultimately, it fundamentally undermines the credibility of the rule of law itself. People lose faith. They might feel the system doesn't work, maybe even look for extrajudicial ways to resolve disputes, which is dangerous. And of course, it's just a massive waste of resources, time, and money for everyone involved. The courts, the litigants, the whole country, really, and for you, the citizen, just seeking timely, effective justice.
What a comprehensive and sobering deep dive. From the intricate financial balancing acts of the Finance Commission to the profound impacts of emergency powers, and then this complex, evolving, and frankly challenged saga of judicial appointments and pendency. We've really seen how interconnected all these parts of governance are.
Indeed. You see in each element this continuous tension, don't you, between state power, individual rights, efficiency, and the fundamental pursuit of justice, the challenges these institutions face, the lessons often hard-learned from historical missteps, the ongoing debates. It all underscores just how dynamic and sometimes fragile a functional democracy is.
So what does this all mean for you, listening right now? It means that behind every news headline about a government policy or a court decision or a funding allocation, there are these really intricate mechanisms, these historical struggles, these ongoing efforts that directly shape your rights, your opportunities, the very structure of the society you live in. And reflecting on everything we've discussed, especially the struggles within the judicial system, it really raises a vital final question for you to consider. How can we, as informed citizens, help ensure that the ideal of timely and equitable justice isn't just some distant constitutional promise, but becomes a lived reality for everyone, bridging that huge gap between the ideal and the current systemic challenges?